second to last bill, colleagues, file item 18, which is Senator Mendoza's bill, 1406. Good afternoon, Senator. Almost good evening, but thank you for your patience.
Thank you. Thank you, Madam Chair. Members, I'm here to present SB 1406. Currently, the state does not collect information regarding lawsuits against public agencies, so it is difficult to discern if there are any patterns to these lawsuits or the facilities in question. Since the repairs and legal fees associated with complaints are borne by the public agency, many of which receive significant funding from the state, it is in the public interest to collect this data. SB 1406 seeks to accurately track the number of lawsuits that impact public agencies in California, including community colleges and K-12 school districts, to better understand the nature as well as the outcomes of these complaints. Since the law requires that an attorney who serves a complaint against a private business that contains a violation of any construction-related accessibility standard to send a copy of the complaint to the California Commission on Disability Access within 5 business days of sending or serving the complaint. Additionally, the attorney must notify the California Commission on Disability Access within 5 days of a judgment, settlement, or dismissal of a claim. SB 1406 will require the same data collected on accessibility complaints filed against a private business to also apply to complaints filed against public agencies. With that, Madam Chair, I respectfully ask for your aye vote.
Thank you. Witnesses in support? Yes. Very briefly, sir.
Yes, it is brief. Madam Chair and committee members, I am, excuse me, I'm Peter Hardash. I'm Vice Chancellor of Business Operations for the Rancho Santiago Community College District in Orange County. We have Santa Ana College, one of the oldest colleges in the state at 100 years old, and we have one of the newest, Santiago Canyon College, that is 12 years old. Current law requires that an attorney who serves a complaint containing a claim of a violation of any construction-related accessibility standard with respect to a place of public accommodation to send a copy of the complaint to the California Commission on Disability Access within 5 business days of sending or serving the complaint. In recent years, there has been an increase in the number of lawsuits against California community colleges and K-12 districts, including the Rancho Santiago Community College District, citing construction-related accessibility violations. These types of lawsuits can result in facility modification and upgrades that are not in alignment with the Division of State Architect approved ADA construction plans. These lawsuits also ignore the availability of funding for these repairs and instead put a strain on a district's general fund. This ultimately affects programs and services offered to our students. In addition to the costs associated with the renovations, K-12 school districts and community colleges have incurred significant costs from the legal fees associated with these lawsuits. SB 1406 is an important bill for the Rancho Santiago Community College District and the Orange County Community College Legislative Task Force, as the state does not currently collect information regarding these lawsuits. Repairs and legal fees associated with these lawsuits are borne by the educational institutions, which receives the bulk of its funding from the state. SB 1406, in turn, will now allow for the tracking of the number of lawsuits lodged against public entities. This will help illustrate the problems and outcomes regarding accessibility claims. Thank you for your consideration of SB 1406, and I respectfully request your aye vote.
Thank you very much. Other witnesses in support?
Thank you, Chair and members. Mark McDonald, McCallum Group, on behalf of the Foothill De Anza, Los Rios, South Orange County, and San Diego Community College districts in support. And I would just say this is a data collection bill so that at the state level we can understand better what's going on exactly.
Thank you, sir. Next witness.
Madam Chair, Chris McHaley on behalf of the Civil Justice Association of California in support of the measure.
Thank you.
Chelsea Von Geer with Townsend Public Affairs on behalf of the Coast Community College District, the Orange County Community College Legislative Task Force, and the Kings Canyon Unified School District in support. Thank you.
Thank you. Any other witnesses in support? Witnesses in opposition? Any witnesses in opposition? All right, seeing none, bring it back to the committee. Thank you for this bill. I think information's always helpful to have, and I noted there was some last-minute concerns by the disability community, which I'm sure you will address. And with that, Senator Morlock, would you like to make a motion?
Yes.
All right, there is.
Make a motion.
All right, there is a motion.
I'll make a motion.
All right, very good. Madam Secretary, the motion is due pass to Senate Appropriations. Please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Aye. Morlock, aye. Anderson? Hertzberg? Aye. Hertzberg, aye. Leno? Monning? Wachowski?
All right, we have three votes, excuse me, and we'll place that matter on call.
Thank you.
Item is file item 10, SB 1166, which I will present and hand the gavel over to my colleague.
Have the floor.
Thank you, Mr. Chair. And Mr. Chair, first, I would like to start by saying I have agreed to take the suggested amendments in Judiciary. Hold on one second. All right, I've agreed to take those amendments. They are reflected in the mock-up or the actual bill that we have before us. Those amendments have already been addressed and I believe are in the file today. Any question about that? If I may just have a moment.
I'm sorry. I apologize, Madam Chair.
That's quite all right.
The amendments are in the analysis.
Very good. Thank you very much. Okay. We have increased with those amendments the employer size threshold to 10 or more employees and require that an employee have worked for the employer for at least a year and for at least 1,250 hours in that year to be eligible for job protection while caring for a new child. The amendments, I believe, remove the concern that this would leave what could be stacked with additional CFRA and FMLA leaves so that we are now in alignment and I think have addressed the concerns that were expressed by some of the opponents of my measure last year that there could be tacking on for illnesses. California falls behind the District of Columbia, Maine, Massachusetts, Minnesota, Oregon, Washington, and now New York in providing job-protected parental leave for small business employees. Under current law, only those who work for employers who have 50 or more employees are eligible for job-protected parental leave in California. That leaves more than 40% of California workers without any job-protected family leave and leaves many new parents struggling with an impossible choice between the well-being of their new child and their family's financial security. Experts, including the American Academy of Pediatrics, recommend that healthy full-term infants should not be enrolled in child care until they are at least 12 weeks old, due to rapid development changes and risks of quickly developing severe undetected illness. If you don't allow parents to take that time off, they will have to put their child, their infant, in some kind of care, and that we know is counterproductive and contraindicated for a newborn. While California's worker-funded paid family leave program provides employees with partial wage replacement while caring for a new child, Many employees are unable to use this benefit for fear of losing their jobs. And so they have to choose whether or not they are going to care for their newborn or keep their jobs. In fact, in 2011, a field poll found that almost 2 out of 5 employees who are eligible to use paid family leave did not apply for the benefit, chose not to because they feared losing their jobs or other negative consequences at work. This measure ensures the California workers who have been paying into the paid family leave insurance program are able to use this benefit for parental leave without risk of losing their job. This is simply fundamental as we talk about family values, as we talk about the needs of our children and our society to have children loved and cared for and nurtured by their parents and their loved ones, particularly in the first critical 12 weeks of life. To say you have to make that choice is just absolutely incomprehensible if we are going to try to meet the goals in our society today. If the employer, I might say that, again, 10 employees or more, so we're going from covering that 40% to about 26% of those uncovered people because of the 50% threshold, now down to 10 employees or more. We really need to address the reality with more and more women in the workforce today, more and more working mothers in the workforce today. We have to recognize the importance of giving those men and women, this is both parental leave for fathers and mothers, the opportunity to bond with their children, which is consistent with all the literature and the findings of the medical profession as to what is in the best interests of a child. With that, I would ask for your aye vote.
Good afternoon. My name is Rachel Langston, and I'm a staff attorney with the Legal Aid Society Employment Law Center. We're a nonprofit organization which advocates for low-income workers and their families, and we are a co-sponsor of this bill. I'm proud to be here in strong support. I'd like to start by thanking Senator Jackson for her continued championship for this important issue. Nearly all private employees pay into the Paid Family Leave Fund. It's entirely employee funded, and it is entirely underutilized. And as you've heard, that is largely because employees are fearful of taking that leave, knowing that they have no job, they may have no job to come back to. We hear from many of these employees and have to advise them if they work for a smaller employer, you have the right to this pay, you paid into this fund, you have the right to this partial wage replacement, but that's not to say that you necessarily will have a job to go back to. And so it's really a very difficult choice and not much of a choice at all, to be frank. One of the individuals that we recently heard from, Alfonso Garcia, is a tow truck driver and also a first-time father who called us shortly before he was to celebrate his first Father's Day. Alfonso's newborn had a health condition which required numerous hospital visits. His partner was still recovering from childbirth, and so Alfonso was hoping to have time both to care for her and to take their baby to doctor's appointments and spend time caring for the baby. Unfortunately, Alfonso's employer only had about 35 employees. And the employer, it was therefore at the employer's discretion under current law as to whether or not he received any sort of leave. He got a couple of days and was left to struggle with what to do, how to spend time with his baby. He just didn't have that time. Allowing workers to access the paid family leave benefits that they fund is not only beneficial for workers, but it also is beneficial to their employers as well as to the state. Workers' ability to maintain their employment while bonding with a new child decreases their need for unemployment and other state-funded benefits. Furthermore, over 90% of businesses reported that workers taking paid family leave had either a positive or neutral effect. Nearly 87% reported that paid family leave had not resulted in any cost increases, and nearly 9% reported cost savings because of reduced turnover and reduced employer-provided paid leave. In short, SB 1166 would do away with the untenable choice between a worker spending time with their new child and maintaining their economic stability. For these reasons, I respectfully ask for your support for working families in California by voting in favor of this important legislation. Thank you very much.
Thank you, Ms. Langston. Are there any other witnesses in support?
Thank you, Mr. Chair. My name is Mariko Yoshihara. I am here on behalf of the California Employment Lawyers Association. We're also proud co-sponsors of this bill. We have over 1,200 attorneys across the state that represent workers in various employment matters, including access to family leave. And unfortunately, many of our attorneys have the same experience as Rachel described, having to turn away workers who were retaliated against or who lost their job because they took family leave. And it's simply because they weren't covered under our family leave laws. One of our attorneys represented Sabrina Summerfield, who unfortunately couldn't be here today, but I do want to tell her story. Her little sister and grandfather were killed in a car accident, leaving her 3 nephews without a caretaker. So she and her husband decided to adopt the 3 children, and while she was going through that process, she asked her employer for family leave, and after asking for that leave, she was fired. But the employer only had 30 employees, and therefore she was not covered under our family leave laws. And this is a common reality for many workers in California. In a 2011 study by the Center for Economic and Policy Research, they found that 37% of respondents expressed concern that if they took family leave, their employer would be unhappy, their opportunities for advancement would be affected, or they might simply be fired. So we believe at a time when financial security and healthcare coverage is so important, it's just a risk that many new parents simply cannot take.
Bless you. Now, if you get sick,
Oh,
you got to have family.
I think that's 2 minutes.
Okay, I will wrap up. Well, California prides itself on leading on leave and having some of the strongest family-friendly workplaces. Right now, we are far behind at least 9 other states, and so we simply would like California to catch up, and we strongly urge your support.
Good job. Ms. Koyishihara. Did I get that right? No.
Mariko Yoshihara.
I tried. Never mind.
It's getting late.
Thank you. Any other witnesses in support?
Thank you, Mr. Chair, members of the committee. Jessica Bartholow with the Western Center on Law and Poverty and Support.
Michael Young, California Labor Federation, also here in support.
Any witnesses in opposition?
Friend.
Good morning, Mr. Chair and committee members. Jennifer Burr on behalf of the California.
morning.
Oh, it's actually evening, actually.
Could be morning already.
I can't remember which committee I'm in. Jennifer Burr on behalf of the California Chamber of Commerce, and we are opposed to this bill. We appreciate that the senator has increased the employee threshold to 10 employees, but from our perspective, that is far too low for an employer to take on a 12-week leave of absence, protected leave of absence, which means you as the employer do not have discretion to deny the leave. You have to provide it regardless of whether their business issues are going on. In California, we have obviously a list of protected leaves here that a lot of employers have to deal with, and you have no consideration when it's protected to say, hey, I have another employee who's already out on disability leave. I have another employee who's already out on paid sick leave. I have a separate employee who's out who is on another protected leave. Can we try and work this out where maybe you come in 3 days a week and are at home 3 days a week so we can cover the business needs as well as your personal needs? Once it's a protected leave of absence, that conversation's immediately gone. You don't get the opportunity to have that conversation. It's just up to the employee as to when they want to take the leave, and you're required to pay for it or provide it. Otherwise, you're subject to litigation. The fact that this isn't a paid leave of absence doesn't take away the fact that it actually is a cost to the employer. While the employee is out on leave, the business continues, and the employer has to find temporary help to provide them with the assistance while the employee is out on leave, or provide overtime, increased compensation for those employees who take on the additional work. So there is a cost to the employer. With regards to the existing paid family leave program, the proponent suggested that the employees are not taking this leave because it's not a protected leave of absence, and we actually disagree with that. A lot of the smaller employers are providing this leave for their employees because they are like family, and it's a small-knit group, and they want to accommodate the personal needs of the employees. It's just not the mandated leave that this bill proposes. Additionally, in AB 908 that was just signed by the governor, which increased the wage replacement that is offered under the paid family leave program, the Senate Labor and our Industrial Relations Committee analysis last year specified that a study found that over a third of employees aren't taking the leave, not because it's not protected, but because the wage replacement wasn't high enough. And that was what AB 908 was offering or trying to address, was the wage replacement amount, not the protected leave aspect of it. I want to highlight again that this is applicable to 10 employees or more. Employers with only 5 employees are already required to give up to 4 months of disability leave for pregnancy-related conditions, and then this would be subsequent to that, providing 4 months plus another 12 weeks, which is a significant burden for these employers to deal with. For those reasons, we're opposed.
Thank you.
Mr. Chair and Madam Chair, Chris McKaylee on behalf of the Civil Justice Association of California. We're opposed to SB 1166, as Senator Jackson knows from last week's Labor Committee hearing, because it would make it an unlawful employment practice to not provide the mandated leave under this bill, which we believe will result in great exposure to costly litigation by the business community. We cited the Hiscox insurance provider study, which found that in California, employers are 40% more likely to face discrimination claims, and they specifically cited to our Fair Employment and Housing Act as the major basis for that. They also determined that on average, such a discrimination claim filed under FEHA through settlement costs roughly $125,000, including defense and settlement costs. That is a considerable sum for any size business, and for that reason, we are opposed to the bill. Thank you.
Thank you, Mr. McKaylee. Any other witnesses in opposition?
Good afternoon. Matthew Allen, Western Growers Association, also opposed.
Brian Little with the California Farm Bureau Federation in opposition.
Nicole Rice, California Manufacturers and Technology Association, also opposed.
Any questions from my colleagues on this bill? Senator Jackson, would you like to close?
Thank you for this robust discussion. This is an important issue, and I have to say that I find myself absolutely befuddled that in today's world, where we need to recognize the importance of business and the importance of workers, and that one doesn't exist and can't exist without the other. And we are talking here about creating the future of our state, trying to provide as best we can for both our employers and the workforce of the future, and our society of the future, and the people of the future who are going to be the leaders, going to be the individuals who comprise the state of California. We want them to be good citizens. We want them to be respectful of each other. We want to reduce the mental illness and the violence and the disrespect that we see in our society. And it is very clear that among the best paths, I think, that are uncontroverted to attain those goals, to create a better society, a more civil society, a more productive society, is to allow for the development of the relationships that make us human beings. And the primary relationship is the relationship between parent and child. That's the primary one. And as children grow, they develop other relationships. But as infants, there are no relationships more critically important to the well-being and development of human beings than having a relationship with their parents or with the people who will be parenting them. I don't think there's any argument about that. Why we find ourselves hearing from the business community that this is going to cost business, when in fact it does not cost business. We are talking about unpaid family leave of 12 weeks or employee wage-replaced income to these workers. The employer's only responsibility during this entire 12-week period of time is to pay for the cost of health insurance. That is it. There are so many other societies in this world today who are so far ahead of us, who actually pay. The employer pays for this leave.
Excuse me.
I thought I was on the floor for a moment. Who pay for this leave. We don't even, our employers are not being asked to pay for this leave. What we are saying, or what we are asking with this bill is, who are we as a society? Are we going to try to value and recognize and encourage the development of these critically important relationships at the most critically important time? Or are we going to say, well, employers, they have problems, or they're going to have litigation? You know, there's one thing about being pregnant. You're not a little bit pregnant. You don't a little bit give birth. It's not something you can take to a workers' compensation board and argue that someone really doesn't have a neck injury. When someone is pregnant and gives birth, there's no argument about that, or at least there shouldn't be, or you adopt a child. What this bill says is if you have an employer of 10 or more, and you have someone who is caring for a newborn, whether adopted or their own, they should have the right to take 12 weeks of unpaid leave without the fear of being fired. I'm a lawyer, and I like to think of myself as creative. I cannot think of how a lawsuit will emanate from the fact that someone who has just given birth, or a spouse, or a dad, or a partner to that relationship, there's going to be a question about the validity of that. They're taking 12 weeks, that is 3 months, to care for that newborn child. And if you have taken care of a newborn child, you also recognize the difficulties in assuring that you're going to be well rested and well able to face work the very next day, and provide that mechanism of 8 full hours or 10 full hours of work as coherently as one might after you get over the hump of early caring for a child. And to ignore what goes on in those early weeks and days and months of a child's birth is astonishing to me. In fact, so astonishing that I read here a letter from the Bank of America, of all places, which has announced early in April that they have extended its paid time off for maternity, paternity, and adoption leave from 12 to 16 weeks. They have a policy there. They recognize the importance, and there are other employers and good employers who do as well. But for people who work for companies where they refuse to recognize and honor the importance of that relationship for new parents, this is a bill that says the state of California, not first, not second, third, fourth, fifth, but 11th in this country, are willing to recognize the importance of this leave for families. And it is on that basis that this law has been introduced. And as I mentioned, I added a provision that you had to have worked for an employer for at least a year or 1,250 hours. I cannot imagine, it is beyond my comprehension, that we are getting resistance from this, for this legislation, although I understand that when we don't recognize the importance of these relationships and think that the only thing of value here is getting someone to work 3 days a week, or 4 days a week, or 5 days a week, while still requiring that they balance the responsibilities they have for newborns. I hope that we can get past this at some point, and I consider this bill to be a first step in that process. And with that, would ask for an aye vote.
Thank you, Senator. Do I have a motion? Do we have a motion? This is to accept Senate Bill 1166 with amendments.
Correct.
Why don't we go ahead and take a vote?
The motion is due pass as amended to Senate Appropriations. Jackson?
Aye.
Jackson, aye. Morlock?
No.
Morlock, no. Anderson? No. Anderson, no. Hertzberg? Leno? Monning? Wachowski?
So that's 2-1. I'm sorry, yeah, 1, 2, and we've got that on hold as well. Senator Jackson, I believe you have the floor again.
I'll ask her.